For this video, we are going to discuss Article 150 of the Revised Penal Code, which is the crime of disobedience to summons issued by the National Assembly, its committees or subcommittees, by the constitutional commissions, its committees, subcommittees, or divisions. Article 150. Disobedience to summons. The penalty of arresto mayor or a fine ranging from 40,000 to 200,000 pesos, or both such fine and imprisonment, shall be imposed upon any person who, having been duly summoned to attend as a witness before the National Assembly, its special or standing committees and subcommittees, the constitutional commissions and its committees, subcommittees, or divisions, or before any commission or committee chairman or member authorized to summon witnesses, refuses without legal excuse to obey such summons, or being present before any such legislative or constitutional body or official, refuses to be sworn or placed under affirmation, or to answer any legal inquiry or to produce any books, papers, documents, or records in his possession when required by them to do so in the exercise of their functions. The same penalty shall be imposed upon any person who shall restrain another from attending as a witness, or who shall induce disobedience to a summon or refusal to be sworn by any such body or official. These are the punishable acts under Article 150. First punishable act: refusing without legal excuse to obey the summons of Congress. I am referring to both the Senate and the House of Representatives, the constitutional commissions. I am referring to the Commission on Elections or COMELEC, the Commission on Audit or COA, and the Civil Service Commission or CSC. Or by refusing without legal excuse to obey the summons issued by any commission, like for example the LTFRB. It is a body that has the power to issue subpoenas or summons requiring persons to appear before such body in relation to the franchising of a public convenience, or committee chairman or member authorized to summon witnesses. Second punishable act: refusing to be sworn or placed under affirmation before such bodies. Third punishable act: refusing to answer any legal inquiry or to produce any books, papers, etc. in the possession of that person subject to such legal inquiry, when required to do so in the exercise of their functions. Fourth punishable act: restraining another from attending as a witness in such bodies. Fifth punishable act: inducing disobedience to a summons or refusal to be sworn by any such body or official. Let us discuss each of these punishable acts in the succeeding slides. This is the key phrase with respect to the first punishable act. Conversely, an example of a legal excuse is when the person so summoned cannot appear before the Congress or before the constitutional commissions or before any committee that has the power to issue summons because or for health reasons. Now, when you say summons, this is a written order requiring a person to appear before such bodies. So, just take note of the key phrase and also take note of the key words, the underlined portions of that key phrase. The refusal to be valid must be with a legal excuse. Now, if there is no, or if the person summoned to appear cannot offer a valid and or legal excuse why he failed to obey the summons, then he will be or he might be charged under the first punishable act of Article 150. Second punishable act. This is also the key phrase found in the second punishable act, refusing to be sworn or placed under affirmation before such bodies. When you say to be sworn or to be placed under affirmation, it means that the person summoned before he proceeds to testify must take an oath. Now, what is an oath, or what is the importance of an oath? An oath is an attestation by which a person signifies that he is bound in conscience to perform an act faithfully and truthfully. It involves the idea of calling on God to witness what is averred as truth, and it is supposed to be accompanied with an invocation of his vengeance or a renunciation of his favor in the event of falsehood. Can you just imagine the importance of an oath? Whether you are a believer of God or not, before you take the witness stand, you must take an oath. And like what I said, and as you can read from the slide, it involves the idea of calling on God to witness what you are about to tell before such bodies. Hence, the reason why the person summoned to testify before such bodies must be sworn in is in the event that he makes a false testimony, he can be held criminally liable for perjury under Article 183 of the Revised Penal Code. Third punishable act, refusing to answer any legal inquiry or to produce any books, papers, etc. in the possession of the person so summoned when required to do so in the exercise of the functions of such bodies. Now, if the refusal to answer any legal inquiry or the refusal to produce the books, papers, etc. would incriminate the person so required, that person may refuse to do so. Reason? He cannot be compelled to be a witness against himself. That would violate his constitutional right against self-incrimination. Now, the phrase "in the exercise of their functions" means that said bodies may compel a person to answer any legal inquiry or to produce such books, provided the same are matters which the said bodies have jurisdiction to inquire. Congress, for example, cannot investigate a crime with the end in view of filing a criminal action against a person because that is a function of the prosecuting agencies of the government, like the DOJ, the prosecutors. But Congress may investigate a crime not for the purpose of filing a criminal case against a particular person, but in aid of legislation. That is, with the end in view of passing a law. Fourth punishable act, restraining another from attending as a witness in such bodies. Now, the restraint here may be physical or psychological. I am referring to the offender who restrains a person summoned to appear before such bodies. And this is akin to obstruction of justice in relation to the investigation and prosecution of crimes. But I am not saying that the one restraining a person summoned to appear before such bodies is liable for obstruction of justice. No, because when you say obstruction of justice, it is in relation to the investigation and prosecution of crimes. Fifth punishable act, inducing disobedience to a summons or refusal to be sworn by any such body or official. Take note, the mere act of inducement is already punishable. The person doesn't have to be induced, meaning to say, the person summoned by Congress, for example, to appear before such body doesn't have to be actually induced before the crime may set in. Like what I said, the mere act of inducing already consummates the crime. Now, one last important note. The reason why disobedience to summons is penalized under Article 150 of the Revised Penal Code is that experience has shown that mere requests for information are often unavailing. Some means of compulsion is essential to obtain what is needed. Hence, if the person summoned by Congress refuses to take an oath before proceeding to testify, he could both be held in contempt by Congress, either by the Senate or by the House of Representatives, and he could also be criminally liable under Article 150 of the Revised Penal Code. And that will not be violative of the right of a person against double jeopardy, because Congress has the inherent power to declare a person in contempt, which is separate and distinct from that person's criminal liability under Article 150.